Welcome back. I am here with Abigail Stolfe, a family law attorney, premier in New Jersey. And we have been discussing the what if. What happens if one of the parties of a divorce passes away? And thankfully, the legislature's plugged the car black hole, but it kind of segued into our off air conversation in that you have a family, and it is that Brady Bunch blended family. You have stepchildren, you may have biological children of the new marriage. And let's just say something happens to the surviving spouse. One spouse has already passed, and then you have the sole surviving spouse, and they die. How how do you counsel stepchildren, especially, and the step and biological children who are basically raised as siblings in the circumstances that let's just say the mom passes away and she doesn't have a will?
Yeah, so this is one of those kind of reverse engineering situations where you have to look at this and say, I really hope that people think about this before we get to the point that the parent or parents have passed. Um, this is not only the case in the blended family, but it's also a case when you're taking people of an older generation and you're deciding to live together and doing prenups or cohabitation agreements. So
Mhm.
this really does go beyond just the nuptials, right? So what I always say is, when you really have to consider in all of these joyous times of your life, you do have to consider, is it time for me to do some estate planning as well? Because what we do know in New Jersey is that if you pass and you die without a will, stepchildren are not entitled de facto by statute. There's just a generic assumption that they're entitled to the estate. That is not what happens in New Jersey. In New Jersey, in order as a child to be entitled to the estate of a parent, you have to be their biological or adopted child. So even though you've been their child and you've known them your whole life, and that is mommy or daddy, under the law, that person is just like you and me, just two
Mhm.
people who happen to know each other. So it's not as simple as going in later and figuring it out. The That's really important because we don't extend to stepchildren in New Jersey if you die without a will. But interestingly, if you die without a will, we also don't extend to grandchildren. So, so the will is a critical document, I think, at any stage of life, but most certainly if you know that you have been diagnosed, or if you're just getting older. And listen, everyone has a time limit. Um, in New Jersey, if you have a will, you can leave your estate to a stepchild. You can leave your estate to a grandchild. Um, and those stepchildren and grandchildren may or may not, depending on where they fall in the tax code at the given time, may or may not pay an inheritance tax, because in New Jersey, we do have inheritance tax, which is different than the federal tax. These are all very deep conversations that you should talk to a lawyer about. But the moral, I think, of the story, at least the story I'm telling, is that you should immediately and at all times of your life have a will, update your will, change your will, be cognizant of the circumstances you are then in, and make sure that your estate documents reflect what it is you want to happen. Because in the event of a challenge, the estate's going to have to prove that you were competent to make the change. So if you wait until you're in a hospital with machines to now try to include your stepchildren, it's not going to happen. Not going to happen.
Well, and in that scenario, it will cost the estate a lot of money to defend whatever last minute, which depletes that legacy, the assets that you could you want to transfer to your children, stepchildren, or grandchildren. I know in my transition from straight being a divorce attorney into estate planning, I focus on the blended family because that's where you have more of that intricacies. And one of the best things that I can suggest to clients of all ages is the will is great when you die. But if you really want to secure, especially in that blended family, having that stability of the new family, but ensuring that your children also reap the benefits of all of your efforts, even prior to and up to that marriage, do the trusts, have it spelt out. I mean, I had a client that fortunately nobody contested it, but he was of the same situation. He had a biological daughter. He had um, two stepdaughters that he adored and loved. One of his stepdaughters had predeceased him, and he loved and adored his grandchildren from them. And he made sure to put it out specifically what they were, and that he was like, my stepdaughters may not be biologically mine, but they are mine. He made his intention well noted. And I think that is important because when you do have a will contest or a contestant of a trust, the intent of the decedent has to be very, very clear. And you mentioned something, so when you do have, let's say, like I've always been a stepmom. I do not have biological children of my own. You know, it wasn't in the cards for me, but I have beautiful stepchildren who I love and adore. And let's say I raised them since they were little. I'm mommy. What is one of the things, or how, I guess what is the challenge in New Jersey of doing an adult adoption? Because we never talk about adult adoptions.
So it's funny that you say that, because a lot of this interest of mine in learning how does the intestate versus probate court work, and what's going on, I'm not just trying to be morbid, right? Although it does seem that way maybe recently. But I have received a few cases recently where people have come to me and said, I want to make sure that my stepchild is guaranteed and is protected, because there are other people who might be looking to reap some benefits that the person doesn't really want, So we have talked about adult adoptions, and I have in the past 6 months performed 2 adult adoptions. And we did them for just this reason, because it was very important in both cases that the children had received, or were eligible to receive, the estates of the stepfathers. In both cases, it was stepfathers who happened to be the moneyed party in that marital unit. And the stepfathers in both cases were concerned that they were going to have challenges, the stepchildren were going to have challenges to their beneficial entitlements. In both those cases, they were working with estate lawyers who had created the appropriate trusts for them, for the children, I should say, and for the grandchildren. But notwithstanding that, they were so concerned about some of the family dynamic that they felt it important to ask for an adult adoption as well. So in New Jersey, to do an adult adoption, we do not need the biological parents' permission like you do, obviously, with a minor adoption. As long as the adult consents to the adoption and the record reflects that it's based upon a parent-child relationship with some longevity, with some parental guidance, some parental control, as you would, as a parent, then the adult adoption is typically very fast and very easy. We don't need to do home studies and all these great things that go with a minor adoption. So that, of course, then takes care of, even if a party should die intestate, meaning they don't have a will, the child would still be able to collect as a beneficiary of the estate as an adopted child. So they would meet the legislative definition of child under the statute, thus avoiding any of the potential challenges. So I can say that, I'm the 70s child, and, I always say, listen, there could be 16 more of me out there. I have no idea because, in the 70s, it was a little more free flowing. So, you never know who's going to come back and say, I get a piece of that pie. So, um, if you want to really protect the people that you raised, that's the best way to do it would be to prepare the proper will, potentially do an adult adoption if that child consents, and really have your estate documents in order.
I'm sorry, I'm cracking up on that. Usually that's the line I hear from, like my boyfriend. There may be more children he doesn't know of. But it is a sure way of protecting the interest of your stepchild, but also legally solidifying that parent-child bond and relationship and love that you have. Um, and one of the other things too is that it takes any of the question mark because you're solidly standing on that platform saying, "This is my son, this is my daughter." Whoever tries to discount that, you don't even bother. I love that. You know what, Abby, thank you so much. Again, oh man, I'm sorry. You crack me up on that last bit. Uh, Setting aside any morbid talk or something, these are gems that you are providing to our viewers, especially when looking at the complexities of future planning, which is what the estate plan is, and also that how to marry the estate plan and protect your estate when going through a divorce. I am Alina Gonzalez Dockery. I'm your hostess of Legal Talk. Thank you so much for tuning in to another episode. And we will look forward to seeing you next week, where we will have more experts providing you incredible opportunities of educating you on the laws that affect you and your family.